body of senior advocates in Nigeria, Bosan, actually said that many matters, including fundamental right enforcement suits, have continued to suffer adjournments owing to the plethora of political cases that are flooding the high courts. So when you have political cases, it's also affecting some people who are suffering as a result of human rights violations, and they're trying to, find justice in the midst of all this. So today on the program, we're taking a look at the nation's judiciary, why it appears to be overburdened with this workload, the impact of so many cases in the judiciary, and how it affects the dispensation of justice in Nigeria. What must we do to ease the burden and improve on the welfare of the nation's judiciary? Now, that's what I would like to find out. And to help me do that, I have a lawyer right here with me. I have Barrister Ezekiel Ogochukwu. Barrister, it's a pleasure to have you here to discuss this very critical issue.
Thank you very much, Stanley. Good morning, Abuja.
Good morning to you too. And I visited a friend who was being held at the Kuje prison one time, and while there, they have this chalkboard, and looking at the number of, which basically has constantly the number of people who are being held there, and I saw at the time the number of people who were awaiting trial. I think they were, a total number I think was about, if I remember correctly, over 1,000, and then out of that about 700 were awaiting trial, and then just about 400 were actually convicts. So this is giving more credence to the fact that the overclogging of our judicial system is making a lot of people suffer unnecessary. And I think that this is the first area of concern. So how do you assess this problem?
Well, the slow pace of our judicial system is a very difficult situation, and gives some of us who are stakeholders in the system worry every time. Just like you mentioned, so many of our, so many defendants suffer unjustly. And so many people are even taking advantage of the system because of the slow pace of administration of justice. A case that ordinarily would take less than 5 months will last for 6 to 7 years. I have a matter that was filed in 2009. As I speak to you, that's 13 years ago. About 13 years, the hearing of the matter has not even commenced. In fact, at the last adjourned date, I think that's 13th of this month, when we were in court, both lawyers in the High Court of FCT and the judge, we all lamented failure of the system. So there is a saying that the wheel of justice moves slowly, but surely. However, in the Nigerian situation, the wheel of justice is not only slow, but very steady. In fact, it appears that the justice system and administration in Nigeria is not moving at all. It's as if it is on a standstill. And the reasons for this is not far-fetched. It is the institution itself. It starts from the institution of the judiciary itself. And the laws, just like you mentioned in your intro, as pointed out by the senior advocate of Nigeria, the basic laws establishing our courts as it is today do not give room for appointment of more judges to take care of the cases in our dockets.
And these laws have existed for how long now?
Since that aspect of our law,
matter?
Yes, it has not been amended.
You're talking 22 years.
Yes, 1999. So we have not amended that. For instance,
23 years, I should say.
For instance, at the Supreme Court, we have matters. In fact, I have a motion at the Supreme Court just for extension of time to bring in our briefs that has been pending since 2000, and I think we filed that motion in 2012. Till today, where no date has been given for the hearing of an application, a motion, not even the appeal itself. Now, coupled with the fact, if you have such clog of matters in the courts and there is no movement, and then every 4 years we will have elections, Before the elections, you have party primaries. And I'll give you an example. In Ebonyi State, for instance, I had the opportunity of listening to discussions, and then we assessed the number of cases in court in Ebonyi State. PDP alone has 53. PDP alone in Abuja State has right now 53 pending cases at the state and federal high court. We are not talking about the Court of Appeal and the Supreme Court. So when you bring in the election, the pre-election cases, and by February, March, you have the post-election cases. That is the tribunals and all that. So our judges are overworked.
They're swamped, yes. And INEC did say that pre-election cases are on the rise.
In fact, as we speak today, notwithstanding the provisions of the Constitution, people are still filing. In fact, fundamental human rights cases, which were hitherto treated as emergency cases, and they ought to be treated so, are no longer considered as emergency cases. In fact, few weeks ago, or a month ago, the Federal High Court, the Chief Judge of the Federal High Court, had to constitute a special task force of judges to determine pre-election matters at the Federal High Court. Because without the determination of the pre-election matters, all other cases suffer adjournments and countless adjournments. As we speak today, at the Court of Appeal, all other matters, land matters, even fundamental human rights matters are not being taken. Only pre-election matters are being taken by the Court of Appeal because there is time limitation, constitutional time limitation.
So that automatically makes it mandatory for the courts to deal with this and suspend
every other matter. I was at the Court of
matter.
I was at the Court of Appeal the other day. My matter was adjourned to May next year.
So it's also a question of emerging challenges because these term limitations were placed to solve a problem. That is the problem where cases are pending, people get sworn in, and then at the end of the day, the court decides that they were not supposed to be the people who have been in that election in the first place. But in solving that problem, we created a new problem. That is now the courts, because the law compels them to deal with this now, automatically have to stand down things of also other matters of national importance because of this. So I am concerned about sometimes the way the 1999 Constitution is drafted. I'm not one of those who feel, okay, throw the baby out with the bathwater, but the Constitution is a living document and can be amended. But the way, you have to admit, that the way some of these things were written, it's almost as if we've boxed ourselves into a corner. Now, we have these limitations that were written into the Constitution. I'm curious as to why, because from what we've witnessed over the years, constitutional amendments are tedious, they're long processes. Very often, more often than not, they don't see the light of day. And usually because you have to take several issues along all together. And once there is one controversial issue, it's either the governors at the state level are fighting it and then these amendments never come to light, or they come to light and then the president withholds assent. So because, again, of political matters, we're not able to deal with some major bureaucratic issues that we have. This limitation of judges, how do we even deal with it? Because we have a constitutional amendment process, I think, that was supposed to be going on. And I don't think even this is one of the issues.
Yes, well, the constitutional amendment is a very tedious exercise. Very, very tedious exercise. But whether we like it or not, we must continue to move. We must continue to move as the trend emerges. As difficulties, as legal difficulties and bottlenecks present themselves, we must rise up and face the challenges. We must, for instance, to solve the issue of backlog. There have been suggestions, but the basic suggestion is that we must amend our constitution.
So how do we protect this amendment from other political issues that come in? Because when the politicians are debating these amendments, having more judges is probably the last thing on their mind. They are thinking more about, how can we prevent the governors from having power over the parties, things that concern them as politicians. So how do we put this front line and center. And I understand that the media has a role to play.
Yes.
And this is part of the reason why we're having this conversation.
Yes.
Agenda setting, that these things are important to do. How can we, is it possible for us to treat this matter in isolation of other political issues that can be brought in and wrapped around this, and at the end of the day we don't achieve this?
Okay, I agree that all stakeholders must come on board. If we have the political will, the amendment to the 1999 Constitution, the fourth alteration, that is the one that gave limitations as to pre-election and post-election matters, was handled differently, and the constitutional amendment was done so quickly. All parties, the State House of Assembly and the National Assembly, they all agreed, and the President signed. And the fourth alteration happened. If we're interested in quick dispensation of justice, and we have found that the amendment to the Constitution as to number of judges and specialized court system is important, the stakeholders can all come together. And when I say stakeholders, I mean the executive. And the legislature, including the first estate of the realm, which is the media, and then some of us from the judiciary. If we all come together and we agree that this is a major challenge, an amendment to the Constitution will go a long way to solving this problem. What that will transform to is quick amendment of the Constitution, and if the Constitution is quickly amended to accommodate appointment of more judges and creation of specialized courts. For instance, if we create specialized courts for pre-election matters and post-election, just like we have the tribunals for post-election matters, if we create specialized courts for pre-election matters, and we have specialized courts for enforcement of fundamental human rights. Now, we have the general courts list for other matters, like land matters and breach of contract. Judges in the general that handle general cases, we have more time to handle those general cases, and they will not suffer as it is today. So, if amendment to the Constitution is the germane thing that we must do, so all stakeholders must come together and push it as a matter of urgency, and the Constitution will be amended and will move forward.
And it's not just because you're mentioning specialized courts,
yes,
and more judges. So it's not, I don't think that this conversation actually should be initiated by the legislature, because essentially they're not professional legal practitioners, even though some of them I'm sure are lawyers.
Yes.
But shouldn't the judiciary itself, or even legal practitioners themselves, look at the design and structure and take all of these things into consideration, the need for specialized courts, and your constituency also has all of the details. You know where all of the stresses and the pressures are, and say we will need at least 10 specialized courts, which will mean that it will require so and so number of judges, and then maybe present that as some sort of structure, or a proposed structure that now can be debated by the legislature, or even sponsored as an executive bill,
yes,
by the presidency.
Yes, this is not the first time that this issue is coming up. On different occasions, both at the conference of the Nigerian Bar Association and in specialized seminars, papers have been presented as to this regard.
These designs.
And then there have been, I am aware that the Chief Justice of the Federation and other justices of the superior courts in Nigeria, they've had retreats involving lawyers and other stakeholders, including the Attorney General of the Federation, where these issues were highlighted, and some very important points were noted and passed to the office of the Attorney General of the Federation. So that's why I say that the most important aspect of faith is the political will. If you have these issues and the Attorney General of the Federation is up and doing, and he convinces the President and the Federal Executive Council to prepare and pass to the National Assembly as an executive bill, you know that once the president sends an executive bill to the National Assembly, they always take it very seriously.
It's taken seriously.
And even the governors, when they see that a bill is coming from, because whether we like it or not, the governors in Nigeria have a lot of influence on members of the House of Assembly of the state. As it stands today, that's the reality.
Yes, so, I want to talk about that a little bit later on.
Yes, that's the reality. So if you have the president, through the Attorney General of the Federation, send in an executive bill for the amendment of the Constitution, we do consultation, of course, with other stakeholders, and that's why I said that all of us are involved. And then it is pushed to the National Assembly. If they do their work as quick as possible and sends them to the various House of Assembly, with the influence of the president, and then, of course, with good media coverage, and other stakeholders come in to have a say, because at the end of the day, members of the House of Assembly will have great job to do. So if that is done, give or take 2 months to 3 months, we have a clean paper, an amendment to the Constitution as regards the appointment of judges and our courts on the table of the president. So I believe that the best way to go is an executive bill sponsored by the president, and the Attorney General of the Federation do have a great role to play in this.
And if he takes this as a legacy project, I think it's something I would really love to see.
I agree completely.
All right, well, we'll have to take a very short break now, but when we come back, I would like to ask more questions about effective ways that justice can be dispensed in Nigeria beyond just the expansion of our pool of judges and specialized courts. So don't go away. We'll also be back with your phone calls.
Hello, Abuja. You are listening to 93.7 Citizen FM, the latest radio station based in Nigeria's capital. Our station seeks to broadcast a broad mix of culture and views with priority given to development programming to enable residents share ideas and opinions, music and drama. At Citizen FM, we believe in progressive talk and solution-driven conversation. Our aim is to build a united Nigeria by bringing people of diverse culture together through communication. Enjoy listening to 93.7 Citizen FM. We are more than just a radio station. We are a part of your life.
Welcome back. This is still Citizen FM 93.7, and you're listening to the Super Citizen at Sunrise. It is the big talk segment of the program, and today we're talking about the judiciary. Are you in court? Do you have a case of which you are desperately seeking justice, but the wheels of justice do not seem to be turning? Are you experiencing adjournment upon adjournment upon adjournment to the point where you're beginning to question your confidence in our legal system? Well, we would like to hear your story. What are some of your frustrations, and how are some of the ways that you feel that justice can be dispensed with much faster in this country? If you have any thoughts on that, the lines are open. You can reach us on 0903 2229 797 or 0818 2222 205 or 0808 2222 037. I'm right here with Barrister Ezekiel Ogochukwu, and we've been looking at the judicial system and, the fact that we do not have enough judges to dispense with justice as we would like. What is recommended is a constitutional amendment and also specialized courts. But beyond that, what about the trial itself or the court sessions themselves? One of the things that, at least I have been in a few court sessions, and one of the things that struck me was how, forgive my word, but there is a clumsiness about the flow. And I think in many cases it's because the judges have to take, basically longhand. I feel for these judges, really, that you have to take what everybody says in longhand and be sure you get everything that they say right. and which means that even the stressed time that you have to deal with these cases is further pressed because you're taking all these things in longhand. And I know that in other countries we have what we call stenographers who are able to do this thing, and then the trial can move faster. So, where are we in Nigeria in adopting these ways of hurrying up proceedings?
Well, the truth is that we are far beyond where we should be in terms of adoption of technologies and fast dispensation of justice. I remember about 5 to 7 years ago, the Federal High Court came up with the issue of having stenographers in our courts, just like you suggested, so that our judges will not stress themselves in writing. But there are so many things, so many factors that hinder that. Not only in our courts, not only in our federal courts, but up to the lower courts at the magistrate court level. The number one is corruption, which is the fabric, which is the problem, the foundational problem of most of our failures in our country. Contracts will be awarded for supply of stenographers. I don't think we have more than 3 or 4 working stenographers as we speak today at the Federal High Court, and whether they are in use. But I am aware that stenographers were supplied as far back as 2010 or so, or thereabout. But as we speak today, whether they are still working, I do not know.
We don't know.
So, I believe that we need to do much more in the judiciary in terms of curbing corruption. Corruption, I mean, is not only in the supply of equipment, but to ensure that such equipments, when they are supplied, work very well. And another aspect of it, because it boils down to the budget of the judiciary. The judiciary must be seen to be independent, financial independence of the judiciary. I know that year in, year out, there are budgets for the judiciary, but there are undue interference from the executive. And if you recall, the union, the Judicial Staff Union, they've been in court for years. Even when they got judgment, implementation of such judgments by the executive was a very difficult thing. If you recall, about 2 years and a year ago, the staff of the courts were on strike. They were on strike simply because they have a judgment and the executive refused to implement. So, if you have a judiciary that is independent financially, that can implement its own budget, I think that I believe strongly that if you have that, they will know their own problems and will be able to factor them in their own budget. And if they are allowed to implement it, they will be able to solve their own problem, because he who wears the shoe should know or knows where it pinches. And then more to it is that we should be able to make available resources in terms of increase in the budgetary allocations to the judiciary. Well, at the federal level, we have something that is a bit okay. But at the state level, I am aware that in some states in Nigeria, some magistrates don't even have official vehicles. Imagine a situation where a magistrate who will go to court, sit over cases of criminals, and sentence some people to prison, will fly back, will use a motorcycle to court, or use public transport. So it is more in our states than it is at the federal level. If you go to our federal courts, you see semblance of sanity there. But go to the lower courts, the magistrate courts, the area courts, you pity the judiciary. So I was in a court in Nasarawa. In fact, I am not proud to say that, and I will never be proud to say that I was in that court. And then
because of the conditions
the
there.
condition of the court, the chairs and all that.
And this brings me back to, we were talking about the governors